I want to introduce you to, if you remember rightly, last year, was it last year? And this year we've certainly talked about as well. Ngāi Tahu brought legal action in the High Court. The court cases or the hearings concluded. But at the end of the day, Ngāi Tahu brought a case against the New Zealand government and the Canterbury Regional Council in particular, effectively seeking some form of co-governance, if you like, of all the water assets in the Canterbury region, as a consequence, they allege, of the Crown and the Canterbury Regional Council in specific, of not, in actual fact, doing their job and looking after water assets in that region. Well, this week, sorry, last week, this week, it was Monday, which was 2 days ago. Kingi Smiler, our next guest, who has traces his ancestors back, he says, quite some time. He established the first Maori-owned dairy company, Maraka Limited. He's led many major investments and developments across dairy, sheep and beef, horticulture and forestry and Maori agribusiness. In actual fact, he's been honoured for that at the Business Hall of Fame for that particular those particular feats. But he announced just Monday afternoon that Maori groups representing landowners Hapu and Iwi had filed proceedings in the High Court on the 26th of June against the Crown, citing its repeated failure to uphold the tikanga-based and Te Riti guaranteed rights, interests and responsibilities of Maori in relation to fresh water. What that's about and where it's going to go to from here, Kingi Smiler joins us now. Kingi, welcome to the show. Lovely to have you on. Thank you so much for joining us.
Kia ora, Michael. Nice to be talking to you.
Have you retired from business, or do you still keep your hand in?
No, still very active, involved with the whānau interests, particularly around our land interests. Absolutely, yeah. So still pretty full on.
So where are you based now?
So I've been based in Wellington for many years, but obviously travel the country a bit and overseas.
Yep. Okay. And you released this press release on Monday afternoon, just outlining what I've just said. Can I ask, when you say you represent landowners Hapu and Iwi, is that of
Yes.
a specific area or is that all over New Zealand?
No, it's all over New Zealand, but certainly the ones that are supporting the claim are specifically from half a dozen regions and half a dozen iwi groupings and lots of ahu whenua and whānau land trusts, etc. But it's the assurances that we're looking for the Crown to honour go back to 2012, and more particularly this affects all Māori, not just particular regions.
Yes, and what you're saying is that in 2012, the then Deputy Prime Minister, National Party Prime Minister Bill English, gave an assurance, and I think I seem to remember that vaguely, about Maori interests and rights and interests in water and geothermal resources. And you're saying that that has not been honoured. Is that correct?
Yes, that's correct. So, I mean, the court made a ruling in that case, which was around the mixed ownership model at that time, around the privatisation of the energy assets at the time. But more specifically, the undertakings and assurances were provided so that, one, the sale process would take place, and equally that the government of that day made undertakings that these issues for Māori rights and interests would be addressed. So we're now over a decade later, and no real progress has been made in that regard. We're having major reforms again of resource management regulations and rules, and so it's sort of come to a time, because there's been no real progress on the matter, that these groups felt the need that we really should to go back to court and seek some really specific assurances from the Crown.
Okay. You've got 3 bullet points in your press release, which I assume the aegis of your legal action. The first is you weren't seeking immediate action to halt further decline in the health and well-being of water bodies. What water bodies in specific are you talking about? Okay,
so again, that covers the country, and you know as well as I do that there's been quite a number of reports on the various water bodies across the country, and many which are not in good shape. And so we have people that will talk to that subject matter with the expertise in that regard, and certainly that applies to many water bodies across New Zealand.
Okay. And the next one is the recognition of Māori tikanga and proprietary rights in water and geothermal resources. Does that mean that you're saying two things here? One, you own some of this water and geothermal resource, or the claimants do, or two, that you expect it to be governed according to Māori tikanga, or at least Māori tikanga to be part of the governance? There are two issues there, ownership and governance.
Yeah, sure. So in terms of the ownership context, Māori have never said they actually own the water, but what they do have is treaty-based rights to access and to control certain of those water bodies. And so it's not ownership in the context of Eurocentric property ownership rights, but definitely there are proprietary rights which have been recognised as well by the Waitangi Tribunal, indicating that there are proprietary rights and interests, and so therefore the extent of that control and use and development of those of particular water bodies is the matter of question, and that's the recognition we're seeking.
Okay, so the end result of this legal action is what? What are you seeking the court to do or to declare?
Yeah, so we're declaring, when they look at those undertakings and assurances previously provided, we're looking for the government to provide a specific action plan that if there is the recognition of these particular rights and interests, then it's for the government then to come up with a specific plan to address how they will honour and resolve those differences.
Okay, but it also says, and then the third bullet point, a fair and durable water allocation system that enables Māori to fulfil their responsibility as kaitiaki. Now, you don't actually have a current legal responsibility as a kaitiaki. Are you? You don't say yes or no from that particular position. Is that what your aim is to do so, and who would have that particular role?
So those roles would be, with respect to the recognition of that, those on those particular water bodies. So that would be locality-based, clearly, and that would be the recognition that's being sought.
So can I give an example? In my neck of the woods, we've got the Clutha River. It's got a couple of dams on it. It's used for irrigation purposes. It is used for, it's allocated for quite extensive irrigation of crops and the like. Would you be expecting to have some sort of role in that allocation process? Is that what you're seeking?
Yes, well, in that context, those would be the Ngāi Tahu Hapu that would have those particular rights and interests. And yes, we would expect to be part of that, because these rights and interests, as I said, also are of a proprietary nature, and therefore a durable allocation process requires that a fair and durable allocation to those Māori interests is appropriate, and that would, as part of that, there would be the ability to agree how the allocations should be done.
Now, Ngāi Tahu have got, it's interesting you mentioned them, they've got their own case, as I said in my introduction, which has been heard in the High Court. Is this complementary of the existing action that Ngāi Tahu are seeking, which is essentially some form of governance role in water allocation in the South Island?
There's certainly many similarities and complementary, but these go specifically to assurances previously provided by government. And so we're looking very directly at honouring those particular assurances that were previously given.
But was those assurances weren't of a legal nature, were they? I mean, it was, well, we'll do our best and blah, 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 but they didn't have a legal status.
Well, actually, we believe that it goes further than that, and that there's they're required to honour those assurances that they provided, and in our view, they do go further than just a best efforts basis.
So what do you think?
Because the best efforts basis, otherwise the assurances that were given are obviously meaningless, Michael, relative to progress made to date. Nothing's happened.
Okay. Well, if they were given in 2012 and it's 2025 and we've had two different stripes of government in.
Yes.
Well, and one of them was a government that believed very strongly in co-governance in terms of water resources, as we know. Why was no progress made for 6 years of a Labor government then?